Afternoon, good evening, and good morning to all of you who are joining us from around the world today for our conversation on the courts, climate change, migrant, and refugee rights. I'm Melissa Stewart. I'm a research fellow and adjunct professor of law at Georgetown Law, and proud to say I'm an incoming assistant professor of law at the University of Hawaii at Manoa William S. Richardson School of Law. As a co-chair of the American Society for International Law's Migration Law Interest Group, I would like to welcome you on behalf of my co-chair, Shana Tabak, and our colleagues and co-sponsors of today's events, the co-chairs of the International Refugee Law Interest Group, Ian Kissel and Alice Farmer. I want to thank everyone at Tiller House at ASIL for their support of this event, especially Taylor Kirkpatrick, as well as our institutional co-sponsor, the Global Strategic Litigation Council for Refugee Rights. It's such a privilege to be joined today by an exceptional panel of scholars, teachers, and advocates who have deep expertise in the field of human rights, the rights of refugees and migrants, particularly in the context of disasters and climate change. It's not possible for me to fully capture their wonderful backgrounds, but I do want to give brief introductions of the panelists that are joining us today. Dr. Jane McAdam is a Scientia Professor of Law and Director of the Andrew and Renata Calder Center for International Refugee Law at the University of New South Wales in Sydney, Australia. She is the author of books such as Climate Change, Forced Migration, and International Law, as well as The Refugee and International Law, and has written prolifically on the rights of migrants and refugees displaced in the context of climate change. Among other titles and roles, she has been the co-rapporteur of the International Law Association Committee on International Law and Sea Level Rise, and a member of the Consultative Committee for the Nansen Initiative on Disaster-Induced Cross-Border Displacement. Thank you so much for joining us today, Jane. Dr. Matthew Scott is a senior researcher and the leader of the Human Rights and the Environment thematic area at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Lund, Switzerland. He is the author of Climate Change, Disasters, and the Refugee Convention, and has written extensively on migration and displacement in the context of disasters and climate change. Among other roles, he has served as a member of the advisory committee of the Platform on Disaster Displacement. Thank you so much for joining us today, Matt. Viviana Kristusevich is the Executive Director of the Center for Justice and International Law, also known as CEHIL, a leading regional human rights organization in the Americas. She worked closely with Chile and Colombia on the request for an advisory opinion to the Inter-American Court of Human Rights to clarify the scope of the state obligations for responding to the climate emergency under the framework of international human rights law. She's a member as well of the UN fact-finding mission on Iran. Thank you so much for joining us today, Viviana. So before we start our conversation, I just wanted to give some brief framing remarks of the context that we find ourselves. So as we know, climate change is one of the most urgent and pressing issues facing society today. Climate change is already leading to increased drought, rising temperatures, rising sea levels, and increasing the severity of disasters around the world. Even if all countries implement their policies to meet their commitments that they made under the Paris Agreement, we are still currently on track for 2.6 degrees of warming above pre-industrial levels, an outcome that would be catastrophic for many communities around the world. Even if we are somehow able to limit warming to less than 2 degrees and avoid the worst impacts of climate change, many of the ongoing changes to our environment are already irreversible, including global sea level rise. During a recent debate at the Security Council, the United Nations Secretary General Antonio Guterres noted that there are 900 million people currently living in low-lying coastal areas, which represents about 1 out of 10 people on Earth. And he warned that rising sea levels could cause an exodus of biblical proportions around the world. Now we know that a vast majority of displacement in the context of climate change that has occurred and will initially occur is internal. But internal relocation is not always possible for everyone facing rising sea levels or other changes to the natural environment, including for those who are living on low-lying island states that are at risk of losing a significant portion or the entirety of their territory due to sea level rise. For others, climate change may be one of several factors that influence a decision to migrate or to seek international protection beyond their country of nationality or habitual residence. Now, the human rights framework is evolving to meet this challenge with recent declarations and decisions from international and regional human rights bodies that recognize a right to a healthy environment and the importance of protecting the rights of those who have been displaced or migrated across borders in the aftermath of disasters or in the context of climate change. Those who face the greatest risk from the impact of a changing climate are leading efforts to push for the progressive development of international law. Just this week, Vanuatu announced that it had received 105 state co-sponsors for its draft General Assembly resolution to request an advisory opinion on climate change from the International Court of Justice. And today we will hear about a similar effort before the Inter-American Court of Human Rights. These advisory opinions have enormous potential to shape the law, and there are many other innovative legal and policy frameworks that are developing to meet the challenge. But there remain significant gaps in the law, particularly with respect to the protection frameworks for those who are displaced across borders in the context of climate change. Through our conversation today, I hope to have a rich discussion on how the law is currently evolving to fill some of those gaps, and what other ways we might approach the response to the needs of migrants and refugees, and the protection and fulfillment of their rights under international law. Now, to start our conversation today, I thought we would first turn to a discussion of climate mobility, and I'm going to turn the floor over to Jane, and I'm hoping that you can ground our conversation to think about climate mobility and some of the important developments in terms of both law and policy that have emerged in the field.
Well, thank you so much, Melissa, for that warm introduction, and thank you to you and to Azel for the wonderful invitation to be part of this webinar. I'm delighted we could get the time zones to work, among other things. Before I begin, I'd like to acknowledge that I am on the traditional lands of the Darramurrugal people here in Sydney, and I pay my respects to elders past and present, and I acknowledge any Torres Strait Islanders and Aboriginal peoples who might be joining us here today. So I think just to kick it off, and to echo some of the remarks that you made in your framing comments, Melissa, there are a number of, I guess, kind of overarching elements that we need to bear in mind when we're having this discussion about mobility in the context of climate change, disasters, and environmental degradation. And I think the very use of the term mobility is one that is, is probably most commonly used now, because it captures the fact that movement is not always, you move and you stop. It can be circular, it can be multiple forms of movement as people are displaced over and over again, or alternatively, it can be circular migration where people move for work and then come back to the home area and then move again. So seasonal, capturing sort of seasonal work. And some of that may be because of flooding in particular areas at particular times of the year. As you emphasised, most of this movement that we're seeing already is internal. And in fact, up to 3 times as many people in some years have been displaced by the consequences of disasters compared to conflict. We don't have very good data in terms of cross-border movement. So no doubt some people are crossing borders, but there are various reasons why we don't know the numbers. And even internally, those numbers are simply a kind of prediction, because as the Internal Displacement Monitoring Centre itself notes, very often they're using proxy indicators to compile those numbers. So if a disaster hits a particular area, they're looking at how many households, how many houses were in that area, how many households, what's the rough number of people living in a household, and kind of multiplying it out to get those numbers. When it comes to cross-border movement as well, we don't have visa categories on the whole that are capturing the reasons for why people are moving. And so in the absence of those, it's difficult to tell, but also there's often a time lag between when somebody might be displaced and when they might eventually end up in another country. And the final point I'd note on that is, just as in any kind of movement, and we see this in refugee law as well, some people emphasise particular factors that have contributed to why they're moving. Others will emphasise different factors. And I saw this in slums in Dhaka in Bangladesh, where people who had all moved from the same rural community to the city all identified different reasons as to why they moved. Some said it was for jobs. Others articulated that as my rice crops were permanently flooded and I couldn't make a living. So that sort of climate factor was coming in. Some people actually said I moved because of the weather. So you get these different reasons being articulated as well. Movement's always multi-causal. So again, in Bangladesh, one official said to me, it's a bit like the straw that breaks the camel's back. If you've already got extreme poverty, a fragile environment, few educational opportunities, and then you add disasters and climate change on top of that, what is it that's triggered your movement? So that's why we tend to describe climate change as a threat multiplier or a vulnerability multiplier, because climate change on its own doesn't drive movement, but it certainly intersects with other drivers of movement. And I'm sure we'll continue to discuss that during this webinar. And the final point I'd make is that, notwithstanding the fact we don't have an international treaty dealing specifically with movement in the context of disasters and climate change, there's not a legal void completely. So we have the application of refugee law in some contexts. We have the application of the principle of non-refoulement from human rights law in others. And it's really a matter of how are these interpreted, and we'll get into that, such that protection can be provided in certain contexts. Law is just one part of this too. It's not the answer on its own. It is part of a suite of options. And again, we'll come to some of those. Just in terms of where we've got to, I've been working in this field now for over 15 years. And at the beginning, it was a very niche area. People would say, oh, I've never thought about that before. And while some people still haven't thought about it, certainly in the global community and among academics, there is now a burgeoning scholarship. There has been a plethora of policy making, policy interventions at the international level, at the regional level, and at the national level. And as you rightly noted in your introduction, many of the most innovative initiatives and kind of really driving the field here are from affected communities themselves. So, I mean, just to give a very quick snapshot of what we've had, you've referenced some of this, the ICJ advisory opinion that looks like it might come to fruition. The International Law Commission of the United Nations is seized with the topic of statehood and the protection of persons in the context of sea level rise. That builds on and interacts with the work of the International Law Association, with which I've been involved for a number of years now, looking at those same issues. Special rapporteurs have taken up this issue and reported on it. Firstly, the Special Rapporteur on IDPs, or formerly when Walter Kalin had the role, representative of the Secretary General for a long time, the Special Rapporteur on the human rights of migrants, on racism, on protection of human rights in the context of climate change. Everybody is looking at this and bringing in the mobility aspect. We've had important language included in the Sendai framework for disaster risk reduction, the Agenda for Sustainable Development, the Global Compacts for refugees, for migration. Committee on the Rights of the Child has a general comment at the moment, a draft general comment, looking at children's rights specifically as affected by climate change. The regional level developments are quite significant. And I'm sure we'll talk more about those. And at the national level, there's some really interesting elements of state practice that we can talk about further. I think what I'd say is that a lot of this was really catalysed by the creation in 2012 of the Nansen Initiative for disaster-induced cross-border displacement. That work is being carried through, of course, now by the Platform on Disaster Displacement. And I think that was a way of states, it's an intergovernmental process, states themselves driving some of the questions and solutions, but in a very broad church, bringing in experts from international organisations, from academia, from affected communities, NGOs, faith-based groups, you name it, and with concerted efforts to have direct consultations all around the world with all of those groups and affected communities. So we have come a long way. Arguably, there's still a long way to go. But I think if you'd asked me 15 years ago, what do you think the landscape will look like now? I don't think I would have imagined that quite so much would have been generated. Thanks.
Thank you so much for that overview of the field broadly and where we find ourselves. And I think that your remarks talking about the applicability of the Refugee Convention and other frameworks of protection, such as the right to non-refoulement, leads really nicely into what I'm hoping, Matt, you can sort of set the stage for, to giving us an overview of the current legal framework and the specific focus on the applicability of refugee law for those whose protection claims are among climate change is among the underlying reasons for their displacement.
Yes, thanks. Just following on from Jane's points about the kind of success of the initiative of the Platform on Disaster Displacement, I'm joining you at this moment at the advisory committee meeting of the Platform on Disaster Displacement here in Switzerland. And just as Jane describes it, it really encompasses a lot more than law and courts. But I'm very happy that we have the opportunity today to talk about kind of the legal dimension and the role of justice sector actors in this context, because it's also important. But everything that Jane says is what we're talking about today. And I'm happy to have this opportunity tonight to shift a bit into some of the sort of international refugee law and other dimensions of the legal frameworks that are relevant in this context. So what I want to do in the short kind of framing moment now is to highlight actually 4 relevant legal contexts where courts play a role, but then I can zoom in a bit on the refugee law context as well. But it's important not to get stuck on the Refugee Convention, because the way I'll present it is in a kind of hierarchy where the Refugee Convention, as we know, is the cornerstone of the international system for the protection of refugees. But it's also got some limitations in terms of the scope for people who are moving across international borders. And so we also look at international human rights law. There are also other mechanisms that are much less discussed, but where I think there is a role, not just in global north countries where we often talk about this phenomenon, but also in countries of the global south. And here I'm thinking about regional free movement arrangements, which are legal mechanisms, but I don't think we've seen a lot of litigation in that context. So I'll point to that as well. And finally, the domestic legal context and immigration law categories. And some of the research we've done recently has focused on that. But starting with the 1951 Convention relating to the status of refugees, we have Article 1A2, which defines a refugee as a person with a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. And the academic and policy work on the question that started off being called climate refugees, and which was soon kind of moved out of the forefront for international law reasons, even though it resonates with wider communities. The starting point was actually to kind of disregard the Refugee Convention from the start for reasons like nature isn't a persecutor, an actor of persecution. So how do you find the relevant agency, the human agency in the tsunami or in the flood? So you can see some cases early on from Australia and New Zealand that kind of articulate those perspectives. And even if you could find an actor, how do you find the nexus point? So these kind of arguments were developed in different contexts, even sort of in the UNHCR space for a while, but it's worth highlighting the most recently issued UNHCR legal considerations relevant to the application of the refugee law and regional protection instruments in this context, because the way the UNHCR is now articulating the application of the Refugee Convention has advanced. And one of the ways that it's advanced is by the recognition that disasters are not natural. This is something I've written about, and I'm happy to see that perspective now reflected in discussions around the application of the Refugee Convention, but it depends on the jurisdiction. And I think that's, again, where we come up with this sort of limitation of the refugee regime, because if you go to New Zealand, you have a very sort of articulated human rights-based approach as developed in cases like AF Kiribati, which really set the scene for thinking about a different way of thinking about the application of the Refugee Convention, where instead of thinking about the actor of persecution being absent in this space, you see harm arising in the context of disasters and climate change. So moving away from this sort of intentional focus towards what happens to a person in a place. And I think there, as I've developed in my work, the role of discrimination is quite significant in that context. So what we see is people who, even before disasters unfold, face systemic discrimination and can be differentially exposed and vulnerable to climate-related or disaster-related harm. But what I've developed is a typology because in the PhD work that I did, I looked at decided cases where natural hazards were referred to in the context of these kind of applications for international protection. And there's different mechanisms or different entry points to refugee protection within that are interesting to maybe discuss further. I know time is short for this overview, but I just want to flag then for 30 seconds or so that there are other regimes, because I think that's really important. And not least, we have the recent, no longer recent, but the decision of the Human Rights Committee in the Taitiota case, which looked at Article 6 of the International Covenant on Civil and Political Rights, emphasizing this concept of the right to life with dignity, which is an innovation which I think we could see more litigation around. And then I just want to mention, because I haven't seen litigation on regional free movement arrangements, I'll just flag that as something that could be interesting to explore. But domestically, we can't forget student visa applications, people who end up surplus, unable to return home because the disaster unfolds in the home country. Can they extend their visa, and what's the role of courts in that kind of context? The exercise of discretion within existing immigration law frameworks and that kind of stuff that we've looked at in some research on Sweden. So I'll stop there. There's at least those 4 legal frameworks and plenty of roles for judicial actors.
Thank you so much, Matt. So in thinking about the legal frameworks that we do have and some of the ways in which there are efforts to sort of push the envelope forward, and I'm very mindful that these advisory opinion efforts are at the forefront of this effort currently, and it's unique that we have 3 overlapping requests that deal with climate change, but the one that's probably most pertinent to the conversation that we're having today is the request before the Inter-American Court of Human Rights, because it directly addresses the rights of migrants and individuals in the framing of the question. And Viviana, I'd love if you could give us an overview of what that request entails, the work that led up to its request before the court, and specifically how it addresses questions around the rights of migrants within the Inter-American system.
Well, thank you for the question. On January of this year, the governments of Chile and Colombia submitted a request for an advisory opinion to the Inter-American Court on Human Rights related to the human rights implications of the climate emergency. Very conscious about the gravity of the situation, but also the need to accelerate policies and the need for further legal guidance on key aspects of that are relevant for the protection of rights of persons in situations of vulnerability, but also are critical at the national level, at the subnational level, and are very important in the development of regional and global frameworks. So the request of those governments didn't only highlight the disparate impact of the emergency on present and future generations, on a variety of rights, of civil and political rights, economic, social, and cultural rights, environmental rights, but also the disparate impact on communities, groups, and nations. And it talked about the importance of the human rights framework, not only because of the way in which those communities and rights were affected, but also as a tool to address the climate emergency in a way that it would be more timely, equitable, just, and sustainable. So this idea of human rights as affected by the climate emergency, but also as a potential tool to better address the emergency bottom up from the individuals and communities, but also creating obligations for nations and across nations is central to the advisory opinion. And the request highlights, amongst other topics, the consequences of the climate emergency for human mobility. And that's very clear for countries such as Chile and Colombia that are countries with large coastal populations and populations with high level of vulnerability living in those areas as well. And those countries are asking the courts to clarify a set of rights and responsibilities that are relevant at the national level, at the city level or subnational level, and transnationally. And the advisory opinion is structured around six questions that are key for understanding the specific and enhanced obligations that states have in order to prevent certain violations and to protect rights in the context of an emergency. So this is a critical area where there are gaps actually in the developments of standards and in the implementation of standards and measures of protections of rights to create the timely, equitable responses that communities need in order to have reasonable measures of mitigation and adaptation that would be in accordance to human rights law. And amongst the questions that the other areas that the governments are asking the court to address are issues related to the preservation of the right to life and survival in the context of the climate emergency, including the extent of the right to information and positive obligations around the production of information that is necessary to address the climate emergency, including the determination of impacts to individuals and groups on situations of forced displacement and migration. Additionally, the states are asking the court to address obligations linked to the rights of children and future generations, on environmental human rights defenders, indigenous peoples, and Afro-descendant communities, including as well the production of information on threats and crimes against those communities and those groups, including forced displacement, and lastly, a question on shared and differentiated responsibilities on states that could be critical for addressing issues of migration. So the governments are actually setting a set of axes or broad topics that will create the possibility of a different type of discussion, we hope, with scientists and lawyers and policymakers, affected communities, human rights experts, academics, on the consequences of the application of the human rights framework to dealing with the climate emergency. The idea behind moving forward with this initiative was to create those spaces for discussion, but also for providing guidance to governments and also communities and regional efforts for developing responses to the climate emergency, so as to accelerate policies, clarify legal standards, engage the judiciary in the control of actions and omissions by states, amplifying the discussions of civil society, youth movements, indigenous peoples, and environmental human rights defenders, fostering the development of interdisciplinary knowledge, which are critical for this area, and also informing the adoption of, or interpretation of new and old regional and global agreements. So it is a pretty ambitious project. We are very hopeful of what the Inter-American Court can do and what these different communities can actually add to the discussion. And I trust, knowing the track record of the Inter-American Court, that the Inter-American Court can do a fantastic job in advancing some of the discussions in a way in which it would be truly useful and important for the Americas and hopefully globally.
Thank you so much, Viviana. Before I get to my first question, I just want to note for all of our participants who are joining us, we will have a section for questions and answers for our last 30 minutes. So please feel free to put your questions in the Q&A, and we'll hope to get to as many as we can later. But so in terms of thinking about how to proceed in this discussion, I hope to get to a broader discussion, as Jane framed it, of the broader tools in the toolkit that we have to address some of these, to address the underlying causes of displacement and to address mobility in the context of climate change. But I wanted to first talk about maybe even using the advisory opinion opportunity as a way to talk about the ways in which courts can be a space for cross-pollination. So while it's not a complete legal void, there are some gaps in the law currently, and as it is an emerging issue that is being addressed in courts, courts are often talking across jurisdictions with each other to think about how to address these issues. We have often cited national decisions like the Agenda decision. We have the earlier advisory opinion on the environment and human rights from the Inter-American system. We have the Human Rights Committee decision in Tetiota, and just thinking about what are the potentials here in taking either this advisory opinion opportunity or some of the national and international decisions that we've seen in terms of increasing that cross-pollination and the strengthening of the legal frameworks. And I'd actually open it up to any of the panelists who want to chime in.
I'm happy to kick off, I suppose. I mean, I think it can go both ways, to be frank. You know, if you look, there was a podcast actually just released this week by the American Journal of International Law, and they were discussing advisory opinions. And Philippe Sands, who's been very deeply involved with certain ICJ advisory opinions, was saying just how important it is, firstly, to have the questions framed appropriately. And he was saying that, you know, for some of those, it's working for years on the questions. And indeed, for the Vanuatu advisory opinion, since 2019. They've been trying to refine those questions with input from states and so on. But it's also looking at the broader judicial composition, context, political environment. And again, Philippe Sands was saying it's so important to understand who is on, who are the judges. We know that, people will bring various things to bear, and it, at the time may not be right to ask a particular question because it may give you an answer that is not the one you're seeking. That said, that sounds very pessimistic, I suppose, but I think it's realistic, because if you don't have, for an advisory opinion, that's one thing, but for an actual case, that's quite another. If you don't have a good test case, you may get an outcome that actually sets things back a number of years. And in terms of the transnational dialogue or judicial dialogue, I think, we're also seeing problems that have come out of the Tessiota matter from the Human Rights Committee. And we may discuss this later on, but one of those is a misguided and erroneous notion that somehow you have to fear harm that is imminent. Now, that is not a test in human rights law or refugee law when it comes to the principle of non-refoulement and when it's safe for somebody to return or not. And if you read that view from the Human Rights Committee very carefully, you can actually see that they're not saying that. But Michelle Foster and I did a survey of pretty much every scholarly commentary that we could find on it, and practitioner guidance, and everybody out there thinks that the Human Rights Committee is saying that harm needs to be imminent before the principle of non-refoulement precludes return. And that's incorrect as a matter of law. The New Zealand Immigration Protection Tribunal has sought to clarify that too in the most recent matter where it discussed that of A.W. Kiribati, which came out in October last year. And in fact, it was the same decision maker who had decided what was the Tessiota matter in New Zealand. Then it was under a different name. But he was trying to clarify that this notion of imminence is not part of the test. And in fact, is there a real risk of harm? Is harm reasonably foreseeable? So again, that's just an illustration of how an idea can start to infiltrate into other decision making with a very, very problematic outcome for people who are seeking protection.
Before I turn it over to Matt, I just wanted to respond to a bit of that. I listened to that same episode yesterday and have been thinking a lot about these advisory opinions. And I think there's some tension here between the urgency of the issue and the desire to want to wait for the opportune case and the opportune time. And, I watched remarks, I don't think it was the Prime Minister of Vanuatu, it might have been the Foreign Minister, who was saying, they were very hopeful in the aftermath of the Paris Agreement that countries were going to come together and create these obligations and make these commitments that would meet a goal of keeping warming well under 2 degrees Celsius. And we just haven't come together to meet that goal. And like I said in the opening, we're on track. We haven't changed our policies. We're on track for actually 2.8 degrees of warming by the end of the century. And I think countries that are facing these real imminent harms, not to confuse with the test of imminence that you just discussed, countries that are facing daily increasing storm surges and the salinization of their groundwater are trying to use whatever tools that they have at their disposal to push the law forward because they feel the urgency. But I do think it's worth noting a degree of caution that that Philippe expressed in that podcast and that others have written about, that you might end up with an outcome that is not advantageous, like we saw in the nuclear weapons advisory opinion. He also mentioned on the podcast that it didn't give the outcome that the advocates were hoping for and led to precedent that has been problematic. And we are going to get into a discussion of the Tessiota decision later, but yes, I just sort of wanted to engage a bit more on your comments there. And Matt, I'm curious to what your thoughts were as well on this idea.
Yes, thanks. And it's a great opportunity to think about this advisory opinion, which covers a range of issues beyond mobility, but of course it's good to see them interconnected as they are. And one thing that I thought concretely that's an important opportunity for the court in this context and in the span of reflection on what the advisory opinion might look like, it's really important to take into account what's already been learned through the Nansen Initiative process and the agenda for the protection on cross-border displaced persons in the context of disasters and climate change, which also addresses other dimensions of mobility. But it would be a lost opportunity to miss the rich guidance and insights that were derived through these 5 regional and sub-regional consultations that articulate effective practices for addressing this issue. Some of them relating to the Refugee Convention, human rights law, but others more perhaps pragmatic and based on evolving practices. And I think that that point also from the protection agenda highlights the regional nature of some of the solutions. And that makes me, I mean, I'm pretty much ad-libbing here, but I think about what I'm hearing discussed here at the advisory committee meeting of the Platform on Disaster Displacement, the significant scope for regional cooperation. And thinking about that in a human rights context, I think, and I've heard these discussions elsewhere, the duty of international cooperation and what might that look like if it's translated into a kind of advisory opinion format, the importance of states within a region, but also between regions cooperating on these enormous challenges related to climate change. So that would be interesting to see. But when we think about that international, the transnational judicial dialogue, I think there we have a little bit of a sticking point because we don't have, I don't think we really see that in the context of cross-border climate and disaster-related displacement claims for international protection or otherwise. I don't know if there's a lot of cross-referencing between different jurisdictions. And I think a starting point might be to initiate processes of trying to compile what kinds of decisions are actually already being taken, because that triggers good conversations. And this I refer back to the research that we did looking at the Swedish context. Colleagues at the Ludwig Boltzmann Institute of Fundamental and Human Rights in Austria looked at judicial decisions in the Austrian context. A colleague in Italy, Chiara Schisa, has looked at the Italian jurisdiction. Camilla Schloss, who's a judge in Germany, has looked at German decisions in this kind of a context. And this is, it's almost like a precursor to judicial dialogue or something, compiling what's actually being decided and then promoting this kind of transnational judicial dialogue, or even regional judicial dialogue in Europe or in the Americas or elsewhere. I think we need that kind of initiative to see how those kind of cases are being decided. There's a bit of a role there for the International Association of Refugee and Migration Law Judges, but it can also be an academic enterprise, or I think there's plenty of work to do in that space.
I would add on the issue of advisory opinions and their relevance, that a lot depends on how those advisory opinions can work in different contexts. And as a litigant, and I've been litigating for almost 30 years before the Inter-American Court on Human Rights, we always look at the potential boomerang effect of any of the initiatives that we take, including cases. And we also look at the differentiated impact that the Inter-American Court and the Inter-American system can have in terms of its grounding on the constitutional law and its impact in legal developments in the region. And if you look at the Americas in terms of the development of the right to a healthy environment and the right to nature, there are over, 17 constitutions that recognize those rights. And we've had a recognition in a treaty of the right to a healthy environment since the 80s. And there's a lot of old and incipient jurisprudence on some of these issues, on preventative obligations and the duties to protect and duties to a dignified life and the protection of human rights defenders and proactive obligations on production of information. So many of the questions that were put to the Inter-American Court on Human Rights cannot go wrong in our region. So, I mean, I'm not doubtful of how we are asking questions that that fall within the legal framework, the constitutional framework, and the international human rights framework, and the doctrinal developments and the jurisprudence of the court. So what we are hopefully asking the court to do is apply it to the climate emergency, not only to the right to a healthy environment, but say, okay, there's a situation of a specific emergency that is going on that needs differentiated steps, different types of information and engagement with different parts of the community. What are the necessary steps to move forward? The court already has some of the moving pieces and the building blocks of the answers that answer the questions that the governments are putting forward. But there's a lack of information. There's a gap, I think, between policymakers, lawyers, scientists, and communities in understanding some of the things that are necessary. Maybe initiatives like the ones that you're mentioning on disasters are critical to feed into those processes, but we have seen it, for example, in the context of looking at indigenous communities or, I don't know, the need to move on super pollutants, that there are gaps. There are significant gaps, and we hope that the court can actually create the space so that we can get further guidance. I don't think that the court should go towards things that are unattainable, but I think that just organizing some of these building blocks and creating a space for interdisciplinary knowledge that will feed, for example, the scope of the right to access to information, that would feed the need to create better protections for coastal communities and bring information to those communities about how to adapt or take steps to mitigate risks will be useful. So I understand from, I don't know, other fora in international law that there might be more of a grain of salt around some of the initiatives. I wish us all good, and I hope that the initiatives create the political momentum for a more just, equitable, and sustainable solutions, which are not happening right now. But I'm pretty confident that because of the composition of the court, the legal framework that we're working on, the communities that are engaged in this process, that the Inter-American system process can actually be healthy for the region. And also, as it did it before with other processes in the European system and at the ICJ, it can also, create solutions and standards that might be taken into account in other regions or in other processes.
Yeah. So I think I saw a hand from Jane and then Matt.
Thanks, Melissa. Yeah, I just wanted to build on something that Matt mentioned, and that was the fact that even if it's not up in lights, there is a lot of case law from around the world where these issues of how disasters and the impacts of climate change affect people who are displaced is being considered. And I remember when I wrote my book about this a decade ago, I was surprised at how much I could uncover, which was not being framed in terms of climate refugee, I hate that word, but anyway, that concept necessarily, but it was clear that some decision makers were considering the broader context in which people were being displaced, where environmental, climate, disaster factors impact, and I'll let Matt speak to this because he's done the most work on this, but really impact the social, economic, political context in which people find themselves. So I think what's important is that we don't have to reinvent the wheel to unlock the potential for protection in some contexts. Now, certainly, it's going to be a minority of people for whom the Refugee Convention is likely to provide an outcome. I'm not trying to overstate that, but the Refugee Convention does have a role to play. And as I said, I'll let Matt speak to that. He literally wrote the book on it. But I think to the extent that we can get decision makers to take a business as usual approach in terms of how they look at cases, but understanding how disasters and climate factor in is most likely to kind of get some of the outcomes we're talking about. Sorry, notwithstanding advisory opinions, I wasn't meaning to say one's better than the other, not at all, but just that we have some tools already at our disposal. And I'd just like to flag a practice advisory, a really useful document that the Centre for Gender and Refugee Studies in the US has produced that analyses asylum claims for individuals fleeing climate change or environmental disasters, and really does do that contextual analysis to say this is what you want to look for if you're an attorney dealing with these sorts of issues. And it might be possible for a link to be put up about that. And then the final point I'd make here, just going back to that question of transnational dialogue, is how important it is to be aware of any legislative constraints or alternatively opportunities in the domestic law of a country you're looking at. So for instance, the way Australia's Migration Act reflects non-removal to cruel or inhuman treatment or punishment requires that harm to be intentionally inflicted. So that's a narrowing that's going to affect the extent to which maybe a disaster can be considered. New Zealand, for example, has a residual humanitarian option, basically, that a decision maker can say, well, notwithstanding the fact that the non-refoulement obligation doesn't apply, because of all these reasons, on humanitarian grounds, we'll grant you a residence permit. So, that might be a reason why, if a decision maker knows they've got that up their sleeve, they may, I'm not saying they do this, but they may not push the analysis as far as another decision maker might in a jurisdiction where they don't have that option available. So I think it's a matter of also being aware of how is this playing out in the local context? Are there tools there that are impacting on how some of these protection claims are being considered? Thanks.
So before I turn it over to you, Matt, I just want to elevate a question that came through in the Q&A. I think it would be really helpful in your comments to clarify, even though it is a minority of cases that the Refugee Convention might be applicable, I think it would be helpful to clarify the situations in which refugee status is appropriate for someone who is moving in the context of climate change. I
could do that now. I referred earlier to a taxonomy, or at least I think I referred to it. As I was, when I did the doctoral research, which then led to this book, Climate Change, Disasters, and the Refugee Convention, I set out to answer the question, in what kind of circumstances might a person establish eligibility for recognition of refugee status in the context of disasters and climate change? And the work that sort of ensued led to the articulation of sort of two categories, kind of broad categories. And this goes a bit to Jane's point about where some jurisdictions emphasize the requirement of intention in the context of persecution, and others, like in New Zealand, adopt a more human rights-based approach, which can have a bifurcated approach to the nexus clause and so on. But I can just flag some of the contexts that have arisen both in the jurisprudence, but also in the academic literature, as well as sort of cases that have been sort of identified as potentially engaging the Refugee Convention, but weren't found to engage the convention on the facts of the case. I'm not sure if we have, I don't think we have a mechanism for sharing this PDF document in the chat, but I'll just point to them. So the category 1 relates to direct and intentional infliction of harm. Here's one example. I've got 1, 2, 3 out of the direct cases, and 1, 2, 3, 4, 5, 6 in the second category, which is other failures of state protection, which, if you're in a jurisdiction that requires intention, are going to be pretty much irrelevant, I think. But where there's direct and intentional infliction of harm, and these are, I think I can just highlight at least these 3, because these are cases that should work in most jurisdictions where the Refugee Convention applies. You have highlighted in cases like AF Kiribati, which is the New Zealand case I referred to earlier. It's from 2013, the New Zealand Immigration Protection Tribunal, recognized in principle that a case like the intentional infliction of environmental damage, such as, and this is the example provided there, reflected in the predicament of the Marsh Arabs under Saddam Hussein. So where there's a malign destruction of the environment that can create a eligibility for refugee status, or situations like the crackdown on perceived dissent relating to the causes or the management of environmental degradation or disasters. We've got cases from New Zealand and Australia, both of them using a number system, so it's not easy to remember, but there's a case, refugee appeal number 76374, relating to that in the New Zealand case, and then there's a refugee review tribunal case talking about a similar scenario. And I don't want to talk too long about this typology, but another is denial of disaster relief to members of opposition political parties, minority ethnic or religious groups, and so on. There was a case, RN returnees from Zimbabwe, a country guidance case in the UK, for example, that recognized that kind of principle. The cases that move beyond the intention paradigm talk about cases where, for instance, the state can't be bothered to deliver relief to populations affected by disasters because they belong to a minority ethnic group or so on. And then there's attempts to stretch the boundaries even further that look to that kind of more discrimination-based interpretation of the refugee definition, which basically you have to read the whole book if you want to have a chance of being persuaded of its potential applicability, but I encourage people to do that. If I can just take, I just wanted to actually say something different, and it connects to this wider question of the transnational judicial dialogue as well as the advisory opinion. Just wanted to flag one concrete example of that kind of the potential benefits of those advisory opinions, especially from the Inter-American Court, where through that advisory opinion on the right to a healthy environment, we've seen that then referenced and followed in the Committee on the Rights of the Child decision in the Sachi case. So that's just one example of a kind of elevation from a regional human rights court to an international context, where there's then the scope for that development of the progressive development of international law. That's probably a good point to pause.
Yeah, so I want to stay on this point for just a little bit longer, and it's open to anyone on the panel to pull in a question from the Q&A from, I believe, my colleague Nicole Nickerson, talking about how we distinguish between people who might have been displaced in the aftermath of disasters or due to causes related to climate change and economic mobility. And I know, Matthew, you have written about and talked about I believe you call it the social paradigm, and other authors have written about, separate from the refugee context, but my late colleague Paul Farmer wrote a lot about structural violence, and so how we really connect these more broader social patterns to the context of disasters and impacts of climate change, and how we distinguish them in terms of the other economic factors that might be also integrated in the reasons or overlapping with reasons that people migrate, in terms of offering protection for people that seek it. And this is open to Matt, but also open to other panelists as well. Yeah, Jane, go ahead.
Sorry, let's hear from Matt and then I can chip in if necessary.
I don't know. I think that's that. Well, where I would come in on that is in relation to the refugee definition. It's that point I kind of referred to in the opening remarks about seeing beyond the hazard. I mean, it's mainstream disaster risk reduction understanding at this point that disasters are not natural and that certain people are differentially exposed and vulnerable to disaster-related harm because of structural violence, because of systemic discrimination. And when you start delving into the disaster risk reduction literature, you understand that systemic discrimination can go back generations. So you have populations that are on the margins for a range of reasons that are clearly readily described as discrimination. And if you want to try to integrate that perspective into an understanding of Article 1A2 of the Refugee Convention, you pretty much need to adopt a human rights-based approach to the notion of being persecuted. And that's what I did in the research that led to the book, inspired by the work of James Hathaway and Michelle Foster in the Law of Refugee Status, but also heavily influenced by the work of Bruce Burson in the New Zealand Immigration and Protection Tribunal in those cases that A.F. Kiribati and A.C. Tuvalu, which became the Teitiota case, really thinking about what it means to be persecuted. And I spent a lot of time in that book kind of unpacking different interpretations and using the Vienna Convention on the Law of Treaties to try to find an interpretation that is aligned with the object and purpose of the Refugee Convention. And there I settle on discrimination as the central organizing principle of what it means to be persecuted, rather than what Hathaway originally defined as the human rights violation. Because when we understand being persecuted as a condition of existence rather than an event that happens, like the death penalty is an act, the execution of a political dissident is an act of persecution. But what I would argue is that being persecuted has a much broader temporal scope, so that we understand that somebody is persecuted even before the execution takes place. And that means that we see things a little bit differently, which addresses some of these issues about like anticipatory flight. So somebody could leave a place where they are persecuted and establish a well-founded fear of being persecuted on return if we understand that being persecuted is a condition of existence. So that's an argument that I have not seen developed in a judicial context. But I would encourage those interested in litigation to consider the possibility, maybe not in those jurisdictions where intention is central to understanding persecution, which is not what the Refugee Convention definition uses. It means being persecuted, and I argue that that's a bit different than persecution.
Jane, did you have anything to add before we move on?
Yeah, I mean, just in response to the question in the chat, I think, that argument that, well, what about broader global economics, structural inequity and that kind of thing. I mean, that's one of the arguments that I made against this idea that we need this new instrument that provides protection to people, displaced by the impacts of climate change, because why single that out? Why just climate change? Why not disasters? Why not economic insecurity? What is it that makes climate change the thing? And I think some of the people who were pushing that line said, oh, well, that's the responsibility of other states, and they have to do something about it. Well, arguably that's the same with economic inequity as well. But also, this is where I think we have to separate out a need for protection from issues of accountability, responsibility, reparations, and all of that. Because the last thing you want to see is someone having to somehow try and prove, which scientists say is impossible anyway, that they've been displaced by a climate impact, and then get into this whole scientific stuff, complexity, when really what we're looking at is what is the harm that this person is at risk of. And that too, perhaps, if I can just move us on to there was a question about this in human rights law, the principles of non-refoulement under human rights law protects people from a real risk of arbitrary deprivation of life, or of torture or cruel, inhuman or degrading treatment or punishment, arguably other things too, but let's just stick with those two. And I think that is where we're seeing some scope. Again, dependent on, as Matt said, how different domestic jurisdictions might put glosses, arguably inappropriate ones, on some of those terms to narrow them down. But, a kind of parallel perhaps is that some of the health cases, the jurisprudence of the European Court of Human Rights, which I've considered in detail in this context. How do you look at, and indeed this is what the Human Rights Committee was doing in Tessiota, looking at cumulative impacts of climate change and disasters in Kiribati, and asking the question, does all of that amount to a risk to somebody's life? And they added from the general comment, a life with dignity. Again, the AW Kiribati case by Bruce Burson from last year picks up on that dignity point as well, questioning, is that the test? I'll leave that aside, but I think, this is where there is scope for movement. Yeah, I'll leave it there. Thank you.
So I think in thinking about some of these comments, it occurs to me that there's some action or changes that are happening directly in refugee law and directly in the instruments of international protection, but there's also these conversations about the structural framework in which we find ourselves for international law. And thinking back to some comments that we made earlier about, finding in these frameworks that talk about the duty to cooperate between states that we found in the draft articles on the protection of persons in the event of disasters. I was reading some work recently by Okafor, who's the independent expert on human rights and international solidarity, who is arguing for a human right to international solidarity that I think it's similar to the duty to cooperate, but it really flips the framework of international human rights and thinking about individuals having a right to solidarity from not just right protection from their states, but perhaps from others in the community. So thinking, really outside the box in terms of where we're pushing international law and how we're pushing the frameworks, and reflecting back to Viviana's comments earlier about, oftentimes there's this gap between policymakers and scientists and the community. And Jane, I know a lot of your work has really focused on bridging those gaps. And so maybe thinking about how we can push the conversation forward in terms of strengthening the human rights frameworks by bringing these different actors together to find practical solutions or pushing the law forward. And I'd really love to hear from Viviana and Jane on this aspect.
Do you want me to go first or Viviana? Yeah, I'll help you. Thank you for the question. I think, when Matt said where he was at the Platform on Disaster Displacement meeting, that, around him, things have radically changed. He would have people from a very vast range of different disciplines and policy areas. And that's one of the big advantages I've always found with the PDD, is that cross-fertilisation of ideas and understandings. If I go back a number of years ago when we started developing guidance on planned relocations under the auspices of Georgetown, Brookings and UNHCR, we brought together people who'd worked on relocations from the development side with people who were now thinking of planned relocations in the disaster climate context. And it took us about 2 days to even start speaking the same language and understanding where each other was coming from. Arguably, you could say those fields are not that disparate, and yet it was a huge challenge to get everybody understanding what we were talking about. So it's not a quick process, but it's an absolutely vital one to ensure that you have all different actors feeding in and understanding the intersections between development, between migration, between mitigation, whatever you want. It's all there. And obviously human rights is key. But I think too, it's important, in fact, it's essential not to lose sight of the contribution, knowledge, and innovations of affected communities themselves. And my closest work in that area has been with Pacific communities. Last year, I had the opportunity to work with Pacific governments and communities to draft a regional framework on climate mobility for that region. Now, I can't speak directly to what's in the framework because it's currently under political deliberation by Pacific leaders. But what I can say is that the human rights framework is there, but it's not necessarily one that is driving people's own conceptions of how this issue should be approached. And what I mean by that is even the human rights framework is sometimes seen as an outsider concept that is being imposed and that may at times cut across people's needs and desires. And one of the things that we sometimes, in this conversation that has to be there, but we haven't discussed it yet today, is the fact that in the Pacific, land is who you are, it's your identity, it's your sense of belonging, it's your sense of where you've come from and what your future is. And bound up with that, of course, are cultural practices that are deeply connected with land and sea. And in many Pacific languages, the word for land is the same as umbilical cord. It's who you are. So to talk about people moving away from land is deeply, deeply troubling. And while on the one hand, there's a recognition that we need to be planning, because if you fail to plan, you plan to fail, there is not a clear sense. There's certainly no sense that it's inevitable that people in the Pacific are going to have to leave their islands. And so, one of the key elements is how do you enable people to stay safely and live with dignity if that's what they want? And I think, interestingly, their migration can actually be a factor that enables that, because if you give people livelihood opportunities elsewhere, generates remittances that go home to help the community that remains, to, in part for adaptation or whatever else it might be used for. But also, if you can relieve some of the resource pressures on those countries by having a smaller population living there on a permanent basis, that too may mean that communities can remain for longer. And there were some very interesting practices that had emerged prior to COVID, but certainly became more entrenched at that time, that were not really ones that we've been considering. We talked about the fact that most people would leave and were leaving their home islands, which are sometimes known as the outer islands, and going to the kind of central main island for work. And yet in COVID, because the airport was on the main island, everyone was told, go back to your home islands because that's where you'll be safer. And in doing so, industries revitalised, communities revitalised, and that notion of internal movement was one that I think had largely been dismissed. So I'm not saying that's the answer, but again, there are options there that I think we need to be careful to think about, and particularly not to impose solutions from on high, because that really cuts across what a lot of communities themselves are asking for. And the final point I'd make too is that the issue of loss and damage and understanding displacement as part of that is really, really important. And I think that's where a lot of communities are pushing for recognition. And that, that's a kind of watch this space.
And I have to echo some of the things that Jane has said in terms of the importance of listening and listening broadly and understanding the diverse solutions that will come up from different types of dialogues with affected communities, lawyers, scientists, academics around the challenges that we're facing. in terms of giving sustainable and equitable solutions to the climate emergency that are respectful of rights. And I see many gaps in terms of looking at what is part of the policy and scientific consensus, and what happens in practice in cases and in the realities of the indigenous communities that we represent in several countries in the region, and what happens at the policy-making level. And not to say that oftentimes the judiciary is lost in how to handle some of these questions. So I see a lot of connecting dots that need to happen so that we learn from each other. Not that we learn of each other, but really we learn and we build knowledge together. And we've seen it in other types of challenges. I remember earlier in my career when developing some of the law on accountability for gross human rights violations, we helped develop with victims and communities and the human rights movement and judges and policymakers and then international courts and concepts like the right to truth and a lot of the rights of victims in international tribunals and concepts of trauma and enormous areas of the law that were developed by creating the spaces for those dialogues and for learning from each other. On dealing with femicides, on dealing with crimes against humanity, on dealing with women's rights and indigenous peoples. And so I see that in this area, with the challenges that we have that are so multifaceted and complex and urgent, we truly need to do much more convening and thinking and learning and creating knowledge together. And we hope that part of the path set by the advisory opinion will allow for some of that. And because it's an open process and the court can actually receive and create spaces for debate, that the academic community will engage, but institutionally with my colleagues and members of the human rights community and the indigenous peoples that we represent and the environmental human rights defenders that we represent, we are truly committed to putting the resources and the spaces to create better frameworks for dealing with some of these challenges, including issues of mobilization, but not of forced mobilization, but not only that. And sometimes rights are derived by legal frameworks, but because of the experience that we've seen in the inter-American system, I think in human rights law in general, we also know that part of the rights are built out of love, commitment, a sense of utopia, of what is just, even earlier than our times. And so I think that right now we have a conviction of the dimension of the crisis that we're facing. We also have a community and a youth movement that is claiming for something different from us. A lot of the indigenous communities and the environmental human rights defenders that are asking for different solutions. And I think that as academics and legal thinkers and entrepreneurs and judges, we also have a duty to engage and try to participate and be up to the challenge. And so I truly appreciate the opportunity of getting to know you and inviting you to come to this part of the world to participate virtually or putting your bodies in here and sharing with members of our legal and human rights community as well.
So I want to continue a little bit further in this vein of thinking about how we're listening to the impacted communities, particularly Indigenous populations, and the mismatch between some of the frameworks that we have at our disposal and the needs and desires of the communities that are impacted. And not just that, but even sort of the ways in which the human rights framework is structured might itself create some of these conflicts. Have been thinking about a recent decision by the Human Rights Committee, the Billy versus Australia decision, that recognized a violation of Article 7 and Indigenous culture for the Torres Strait Islanders that are experiencing some of the same risks of loss of low-lying island states where rising sea levels are creating real challenges for that community. But at the same time, in the decision from the Human Rights Committee, they sort of suggested that a way for the state to avoid a violation of a right to life was to, in the future, potentially relocate that community. And that was one of the things that they were really alleging would in itself be a violation of their Indigenous culture, because they wouldn't be able to replicate their traditional ways of life on Australian mainland. And so to reflect back on the conversation about how we can use these frameworks and to really meet the needs of the populations that are being impacted and reflect the values that Jane was talking about earlier, where land is really so vital, connection and value for a lot of these communities that are impacted and the losses that they might face in the future.
Well, maybe just to start, and I should have, as you were talking, I thought the word for land is the same as placenta, not umbilical cord, which is what I said. But anyhow, sorry about that. Yeah, exactly. But I mean, I found that quite extraordinary that there would be this kind of obligation on the state to internally relocate people, because I mean, I mentioned before that guidance that we developed a number of years ago, and since that time, Fiji, Vanuatu have developed internal guidance on displacement and or planned relocations. Other Pacific countries are doing the same. But I mean, one of the biggest questions is who decides, quite aside from how do you find land for that, because in the customary land tenure systems in the Pacific, and similarly with native title in Australia, it's not just a matter of saying, oh, let's just move you all over here, that'll be fine. Within Fiji, where some internal relocations have happened, to my knowledge, it's been on the same kind of traditional land, so that issue hasn't had to be confronted. But it's a very significant one. And I mean, if I look at Australia's own past, the idea that you just move Indigenous peoples around is still having a very long intergenerational legacy of injustice, of inequity, and so on. So I think that's, while I understand that where the committee was coming from was about you can't just let people be sitting ducks, like you've got to assist them. I think suggesting you relocate people is problematic. And if we look at the very few cross-border planned relocations that have happened, again, in the Pacific region, back in the sort of post-World War II era, there's a long-standing sense of injustice, particularly among one of those communities, that they were forced to move, and that they had no say, and notwithstanding the fact that there were special constitutional arrangements developed so that they could retain the citizenship or acquire the citizenship of the original country, which is Kiribati, stand for election as politicians and have a particular 2 seats devoted to them in the Parliament of Kiribati. So you've got these so-called legal protections of identity of rights. That doesn't overcome that enormous sense of loss and of injustice and denial of agency. So these are areas that need a lot of caution. That said, there have been a lot of planned relocations historically, and Some have worked where the community has been leading them. The Caldor Centre, together with the Platform on Disaster Displacement, published a report called Leaving Place, Restoring Home, which documents many of those, written by Sanjula Weerasinghe and Erica.
We only have a few minutes left. I was hoping to get into a more in-depth discussion on the Tetiota decision. There's so many other questions that I have, but mindful of our time, I just want to give Matt and Viviana and Jane a final minute to sort of have any concluding remarks as you reflect on our conversation and the path forward.
I guess we'll go in that order. The reflection that I have as a concluding one builds on the points that Jane and Viviana made most recently about practices at the regional level in the Pacific and in the Americas. And I'm sitting in Europe, and it feels like this is not the center for innovation. And there's a lot of room for being inspired by the kinds of strategies and initiatives being developed at the regional level, as well as at the national level in some places. We heard today about the initiatives in Chile on human mobility in the context of disasters and climate change, for instance. And in Europe, there was recently released a European Commission staff working document updating the 2013 staff working document on human mobility in the context of disasters and climate change. And the focus is very much over there. In the South, what can we do to address climate-related mobility in Africa, Asia, Latin America, but very little internal, I mean, basically no internal reflection on. So how does it look in this part of the world? And that's because we have quite an infected debate and reality, political reality, where human rights violations happen all the time, whether people are moving because of climate change or disasters or for other reasons. And importantly, these reasons are heavily interconnected. We don't want to talk about it. So I think there's a lot of room for European countries and the European legal order to grapple with mobility into this part of the world. And I think human rights has a lot to do with that discussion, but it hasn't started so much yet.
Thank you so much, Matt. Viviana?
I just wanted to reiterate my gratefulness for participating in the discussion and welcoming your engagement, future engagement in what will become this process led by the Inter-American Court on Human Rights. We're expecting in the next month that the court will pose the questions that it will actually entertain. We don't know whether it will take the 6 topics or it will decide that one will be more than enough. But we're looking forward to that process, and we hope that you will be engaged in it. We hope to translate some of the information so that it's available in different languages, and it allows a broad sector of members of the community and the scientific community, the academic community, indigenous peoples and human rights defenders to participate. So
thank you so much, Viviana, for your valuable work on that effort, and we definitely look forward to hearing more as it progresses. Jane.
Thank you. I just echo the thanks for holding this webinar and for inviting me to be part of it. And I guess as a final point, something that we didn't really discuss at any length was the opportunities that migration can unlock as a form of adaptation. And so that's where I would encourage states to look at, flexibility with visa requirements in the aftermath of a disaster, looking at creating more temporary as well as permanent pathways for movement. And it doesn't mean that you need to create special climate or disaster visas. It's really about looking at your existing economic, labour, mobility, education, family reunion, and seeing how those might be expanded to particularly assist people from affected communities. Thank you.
Well, thank you so much for those final thoughts, Jane. And Thank you so much, Matt, Viviana, and Jane, for joining us today. It was such a privilege to have this conversation, and we're so grateful to the American Society for International Law for creating this space and for supporting the interest groups so that we can bring experts together and have conversations on some of the most important issues in international law today. Thank you to all of you who joined us from around the world at various hours of the day and night, and we look forward to seeing you soon, hopefully at the annual meeting in Washington, D.C. in just a few weeks. Have a good rest of your day. Thank you.